Welcome to episode 59 on the Law Report. Today we are going to discuss the Anti-Gang Ordinance, which was passed in 2022 in response to the spike in crime and violence in the Turks and Caicos Islands. Section 18 of the Ordinance indicates that the Ordinance is in force for 36 months. Upon or before expiration of the Ordinance, it shall be reviewed by Cabinet. This is an indication that the review will determine whether or not the Ordinance is renewed. I'll be back to discuss some things that you should know about this Ordinance. Before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Section 3 of the Ordinance deals with evidence in relation to gang, and it states that it is not necessary to show that a particular gang possesses, acknowledges, or is known by a common name, insignia, flag, means of recognition, secret signal or code, creed, belief, structure, leadership or command structure, method of operation, or criminal enterprise or specialty, membership, age or qualification, initiation, geography or territorial boundaries or location, or other unifying mark, manner, protocol, or method of expressing or indicating membership. Now, this is a pretty low standard. In other words, once the police say so, it is so. This is the standard the Ordinance sets. However, Section A to G set out the kind of activities that will be admissible as evidence of gang membership. A, an admission to being a member of a gang or the leader of a gang. Association or involvement with a gang with intent to facilitate gang-related activities. Evidence of criminal activity by the person that indicates a link or involvement with the gang. Evidence that person knowingly assists or facilitate the concealment, transportation, or disposal of anything of evidential value to gang-related activity. Evidence that the person knowingly concealed or shared in the proceeds of gang-related activity. Any statement made or information given, distributed, or communicated by that person on behalf of or in the name of the gang. And 3, any statement made by or on behalf of the person, whether orally or in writing, and published or otherwise distributed by him or on his behalf, indicating involvement in the commission of a crime by the gang. Section 4, subsection 2 of the ordinance sets out the penalty for being a member or the leader of a gang and participating in gang-related activities. And conviction and indictment, a person is liable to up to 25 years imprisonment. Section 4, subsection 3 of the ordinance sets out the penalty for a person convicted and indictment for performing acts on condition for membership in a gang, professing to be a gang leader or gang member in order to 1. Gain a benefit for himself or another person, 2. To intimidate other persons, or 3. To promote. A gang. Upon conviction and indictment, the person is liable to be imprisoned for up to 25 years. Section 4, subsection 4 sets out the penalty for any member of law enforcement or any person who is involved in intelligence gathering and who in that course commits an offense under this section and he is convicted of an indictment, is liable for imprisonment up to 25 years. So if a person, I suspect, was tasked with infiltrating a gang, being undercover, and then he or she goes rogue and began to participate in gang activities to the point where they are committing crimes, then that person, upon conviction, will be liable to be in prison up to 25 years. Subsection 5 of section 4 deals with members of a gang or a gang leader who wounds or causes grievous bodily harm to a person with intent, or with intent to do grievous bodily harm, shoots at a member of a law enforcement or person involved in intelligence gathering, and upon conviction and indictment, that person is liable to be sentenced to up to 30 years imprisonment. Section 5 creates an offense for coercing or encouraging gang membership. Upon conviction, a person could be sentenced to up to 25 years. Section 6 creates an offense of retaliating or taking retaliatory actions against persons, their relatives, or friends of those persons refusing to become a member, or persons giving information to law enforcement or assisting in an investigation or giving evidence against a gang member or leader, etc. And upon conviction and indictment, that person is liable to be sentenced to up to 30 years imprisonment. Section 7 of the ordinance creates the offense of counseling a gang. person who is convicted of such an offense is liable to be sentenced to up to 25 years. Section 8 creates an offense of preventing a gang member from leaving the gang. A person convicted of such an offense is liable to be sentenced to up to 25 years. Section 9 of the ordinance created an offense of possession of a bulletproof vest, which that person ought reasonably to know would be used in gang-related activities. If convicted of such an offense, that person is liable to be sentenced to up to 15 years in prison. Section 10 creates an offense of harboring a gang member. The person convicted of this offense is liable to be sentenced to up to 10 years imprisonment. Section 11 creates an offense of concealing a gang member. The penalty for this offense is that a person could be sentenced to up to 15 years. Section 12 creates an offense of recruiting a gang member. A person convicted of such an offense could be sentenced to up to 25 years. Section 13 creates an offense of tipping off. A person suspected of tipping off someone that an investigation is being conducted or about to be conducted. And if this information is likely to prejudice the investigation and that person is convicted of this offense, that person is liable to be sentenced to up to 20 years imprisonment. I think that this section should and will catch a lot of police officers. There have been serious allegations about police officers compromising investigation and tipping off persons. I believe that this section is geared towards police officers and those in law enforcement. The issue is that will we know about it or will they be prosecuted? Section 14 deals with the powers of the police to enter premises, to search, and to arrest. Section 14, subsection 3, empowers the police to enter on the premises without a warrant and to search those premises if they are not dwelling houses. This includes the building, ship, vessels, etc. Section 15 deals with detention of persons under this ordinance. A person could be held in police custody in the first instance for up to 72 hours without charge. That is 3 days. And the same applies to the firearm related offenses detention and bail ordinance, which was also amended in the wake of spike in violence in the Turks and Caicos Islands in late 2022. I will deal with that ordinance in a subsequent episode. Now, this section 15, also empowers the Commissioner of Police to order further detention of 72 hours. So, in essence, a person could be held in police custody under this ordinance for a maximum of 6 days without charge and without being taken to court. Anything in excess of the further 72 hours authorized by the Commissioner of Police, then the police must apply to the court for further detention. Section 16 of the ordinance deals with forfeiture of property pursuant to a conviction. So if a person is convicted for an offense under this ordinance, the court is empowered by section 16 to order that property used for or in connection with or obtained or in connection with the commission of an offense under this ordinance to be forfeited to the Crown. There's also provisions that persons claiming an interest in the property can make representations to the court. So if the property is subject to a third party interest, for example, if a vehicle is used and the person using the vehicle was not the owner, maybe they were using their parents' vehicle, friend vehicle, etc., that person could make representation to the court, and the court is bound to hear the representations and then make a decision according to law. Schedule 1 of the ordinance sets out the offenses that would trigger a detention under this ordinance, or that would trigger a person to be held in custody without charge for an initial 3 days, and then a further 3 days on authorization of the Commissioner of Police, and beyond that an application to the court for further detention. So the law before the enactment of this ordinance and before the amendment to the firearm related offenses detention and bail ordinance was that a person could only be held for 48 hours in custody without charge, and any further detention there must be an application to the court. This law changes that and extends the time period beyond 48 hours, and the offenses that are captured in the schedule to this ordinance are murder, manslaughter, theft of motor vehicle, setting fire to building, handling, receiving and disposal of stolen goods, possession of bulletproof vest, firearm, ammunition, prohibited weapon, etc. for the benefit of a gang, threatening to publish with intent to extort, demanding money with menaces, shooting or wounding with intent to do grievous bodily harm, wounding, robbery, assault occasioning actual bodily harm, carrying a firearm or ammunition with intent to endanger life or cause injury to property, possession of firearm or ammunition without license, possession or imitation of firearm in pursuance of a criminal offense, trafficking in a controlled drug or being in possession of a controlled drug for the purpose of trafficking, rape, sexual assault, kidnapping for ransom, knowingly negotiating to obtain a ransom, offenses under the Proceeds of Crime Ordinance, offenses under the Integrity Commission Ordinance, attempting to blow up a building with intent to do any bodily injury to any person, hijacking, assisting illegal entry contrary to the Immigration Ordinance, trafficking in person, contrary to the Trafficking in Persons Prevention Ordinance. So there are 26 offenses listed in the schedule to the ordinance, and the governor under the ordinance is empowered to expand these offenses if there is a need to. These are some of the things that I believe that the general public should know about the anti-gang ordinance, which was passed in the Turks and Caicos Islands in 2022. If you like this sort of content, please share, please like, and please comment. But most of all, I thank you for taking the time to look at this video. And I will see you shortly in episode 60.